I think we can begin. Okay, everyone, welcome to our first Zoom webinar for 2021. We had quite a few webinars in 2020 towards the end of the year, and I'm very happy to state that those were very successful webinars. Quite a few hundred people subscribed to those webinars via Zoom and partook in those specific webinars. If you do find this webinar useful, please share it and invite other people as well to possibly partake in these webinars. I'm just adding some people to this webinar. Okay, let's begin. Okay, today's topic, simple topic, easy topic. Child custody disputes and battles part 3. How do I get the best out of my case? Now, the way these specific webinars works I try to be pragmatical. I try to give you the best possible advice and logical advice. We all know the law. The law is very easy to understand and very simplified. The problem happens in the application of the law. We all know, for argument's sake, that both parents have to pay maintenance, but what if one parent does not pay maintenance? What can you do? So that's the purpose of these specific webinars, in order to educate and to engage with you so that you can have a better understanding of the law, the practical application of the law, and how you can use that information to assist you in your case. So that's why the topic is Child Custody Disputes and Battles Part 3. How do I get the best out of my case? Many people believe that in order for them to get the best out of the case, they just need to employ the services of a good attorney, a good advocate, and there it is. It doesn't work that way. A lawyer's case is only as good as his client's case, and you can make your lawyer or your attorney or your advocate's case very efficient, very powerful, if you make sure that you give your lawyer or your attorney or your advocate the relevant information required to be successful in your case. So let's start off with the first issue, child custody disputes and battles part 3. The general problem which we face as legal practitioners dealing with child custody matters is that of primary care of the minor children. Many parents believe that because I'm the mother, I have the final say regarding my children, and the other parent should follow whatever I say should apply to the kids, despite the law saying that both parents have parental rights and responsibilities in regard to the minor children. So your attitude needs to be correctly aligned to the law. So if you take, for example, the assumption that I am the mother or I'm the father, and I have the sole say as what is best for the kids, and you as the other parent should only listen to what I have to say, you won't get very far with your case. The best way to deal with a matter like that is to determine, okay, I have rights, the other parent has rights. How does the law deal with this matter? The law is not concerned about the mother or the father, what their views are, what their specific prejudices are, the issues they have with the other parent. The law isn't concerned about that. The law doesn't really care about that at all. What the law is concerned with, what is best for the minor children involved. So you can have the best of lawyers, the most of money in your bank account, the most beautiful house, the most beautiful car, but if it is not in the child's best interest for you to have primary care, contact, or custody over the minor children, the court will not grant that for you. So that is very important. You must understand that specific principle, that even if a parent only saw the child for once a month for the last 10 years, but at the inquiry stage, and if the matter goes to court, and the court determines, this parent only saw the child for once a month for the last 10 years, but he or she can care better for the child than the other parent, the court has no other alternative but to give the minor child to the parent who saw the child once a month, because that parent can care better for the child. The circumstances or the facts that the person will have to look at in determining what is best for the child can be manifold. You can look at the age of the child, you can look at the child's preferences, as we'll see later on, but at the same time, the capabilities of a parent to care for a child is very important. So many people come, they go to lawyers and husband and wife, or ex-husband and wife, or ex-lovers and partners. They say, I'm taking you to court, I'm getting custody over the child. That's fine and well to say it in word format, but the question is, will you get custody over the child? You won't get custody over the child based upon saying so. You will get custody over the child based upon the fact of whether or not you can care for the child better than the other parent. So I hope you understand that specific concept. So if someone comes to my office with an attitude in saying, I am the mother of the child, I give birth to the child, I only want the other parent, can be either way, the father can come to my office as well, but I only want the other parent to have contact with the child on a Saturday and on a Monday because I want that. I believe that is best and that is it. I give birth to the child and so on. Please, let's move away from that attitude. Focus on what is important. Give your lawyer something to work with. Say, I want the other parent to only have contact with the child on a Saturday, on a Monday, solely because right throughout the week the other parent works, he is not available, or the child has extramural activities, the child has to attend to X, Y, and Z, and it will not be in the child's best interest for the child to have contact with other parent other than on a Saturday or on a Monday. Monday contact can take place because the other parent is not working, has a day off. So those are the logical aspects on how to deal with these specific matters. So I will jump one time into the questions that were posed. We received 7 questions. Some of them were a bit long, so I will summarize them. I will not put it on the screen. Might just slow us down a bit. Okay, the first question I'll deal with, it goes as follows. The link between child custody and child maintenance. How does the law differ from each other? So this is a typical question I get from people who want to know, is there a link between paying child maintenance and having contact or custody over my minor child? So then I'll ask him the question, so if the other parent pays 100% of the child expenditure, does that automatically mean he or she should have 100% rights over the minor child? That is nonsense. If a parent is caring for the child, let's say for argument's sake the mother, and she looks after the child, but she has no money, she has no income, she's struggling to find a job, or she just cannot work, the court will make an order that the other parent should pay 100% of the minor child's expenditure, because that is in the child's best interest. The fact that you are paying 100% towards a minor child's expenditure does not mean automatically you have more rights. That is your obligation. There's no correlation, or if I pay 100% of the child's expenditure, automatically I'll have 100% of the child's custody rights at my hand, at my disposal. But that does not work that way. It is possible to have a scenario where a parent will pay for all the minor child expenditure, schooling, clothing, accommodation, etc., and even maybe something towards the mother, if it's reasonable and logical under circumstances, but only allow that specific parent to have telephonic contact and maybe supervised contact once every few months. So that's also possible. So it's important to understand there's no correlation between the amount of maintenance you pay and the amount of parental rights you obtain over a minor child. That's very important to remember that and understand it, and to take note of that specific factor. So therefore, I'll just conclude on that question. If a parent pays for everything, we still look at what is best for the child. And if a parent pays for nothing regarding the minor child, it is still possible for that parent to have a lot of parental rights and responsibilities. For argument's sake, the father is unemployed. He cannot afford to pay any child maintenance towards the child at all. The court will still make an order stipulating, sir, if it is best for the minor child to have contact with you on a regular basis, every second weekend, during the week, as the case may be, you will have the contact despite the fact that you have not, or you cannot contribute towards the expenditure of the minor child. So we'll resolve that specific question. I'm looking at a chat over here. I have a live question over here. It says the following: my ex-husband left when my baby was 5 months old. She is now 26 months old, 2 years old. Since then, he has not seen her. Now has two charges of sexual assault against a minor child. So a minor child is 2 charges of sexual assault against him. I have 2 questions. Do I have a valid case to apply for sole custody? If anything happens to me before this happens, who will guardianship of the minor child go to? I have an 18-year-old son. Can I state that he or her guardian in the event anything happens? So, for example, I presume can the 18-year-old son be the guardian? So this is a very, very tricky question. It does not mean, and with respect to everybody, I'm not trying to be insensitive to anyone. It doesn't not mean that somebody has a sexual assault case against him for assaulting a minor child sexually, automatically mean that you can't have any parental rights and responsibilities. You don't look at the logic, it doesn't work that way. Or it says, for example, if a father does not have any case like that against him, you automatically have parental rights and responsibilities. The matter will have to be looked at holistically and generally. We have to look at the age of the child. We have to look at what is best for the child. Can we have supervised contact? Is that possible? So it does not mean that if a father or a parent was acted unlawfully, improperly towards another child, automatically, like a checkbox, if this applies, you cannot have contact to your child. We need to look at what is best for the child. I would say it's possible to have a certain scenario, and I'm not saying it applies to this specific case, where a father can be a sexual predator to minor children, but it will still be in that specific minor child's best interest, the child of that specific father, to have contact with the father, because the child needs to have contact despite what the father has done. And we'll have scenarios whereby it will not be in the minor child's best interest. Each specific case has to be looked at on its own. So my advice to the specific questioner on the Zoom would be, please speak to a social worker. Get a social worker on board and see what the social worker has to say. If the social worker says, no, under these circumstances, after I have investigated this matter, I've consulted the minor child, I've consulted with the father, I've consulted with everybody concerned, I believe it's not in the minor child's best interest to have any contact with the father, or for you to have, I believe it's in the minor child's best interest for you to have sole custody over the child, meaning basically, if I'm looking at a scenario here, that the father cannot have any contact with the child. But there must be a logical and a rational decision being made, not an emotive decision, not a decision based upon quick emotions. It must be based upon logic and reason. Because if the father was a predator to other children, that is totally wrong. But if that is a factual thing, it does not automatically mean he cannot see his current child. But there might be good reasons for that. There might not be good reasons for that. We need to look at the matter completely holistically. And if that is in the minor child's best interest, it should happen. It goes further. My ex-husband refuses to sign a parenting or maintenance plan. He gives maintenance not sufficient, but now has given less maintenance as he got married. Okay, now this is a query I get a lot. It does not, nobody can be forced to sign a parenting plan. The same way, he can draft a parenting plan stipulating that he should have sole custody over the minor children. Then you say, then he comes to my office and saying the mother refuses to sign the parenting plan. Or he can take you to the maintenance court and saying you should pay X amount of maintenance, and you say you can't afford it. Then his complaint is, but she does not want to sign the maintenance agreement. You cannot force somebody to sign a parenting plan, a maintenance agreement, a consent paper, a divorce document, as the case may be. That is only if the parties want to come to an agreement. If the parties cannot come to an agreement, then the matter should go to court. The matter should go to trial, and that is how the law works. So if a client or if someone comes to my office and says the other party wants him or her to sign a parenting plan, I look at the parenting plan, I consult the person in depth, I determine, no man, I agree with you, this parenting plan is not in the minor child's best interest, it's not in your best interest, it's nobody's best interest, I advise you not to sign it. That is his right to do so. He done that on the advice of a lawyer. And if the mother or the other party has a problem with that, then she or she must finalize the matter in court. It does not mean that there's a parenting plan on the table, it must be signed. Let's go further to the specific question. The mommy, let's go here. My son has been given access to his 7-year-old daughter since birth. The mommy, so I presume this is the grandmother writing this message. The mommy and him have never been together since she fell pregnant. My son's name is also not on the birth certificate. What will be my son's right should the mom decide in the future to want to immigrate or deny him access? His daughter is on his medical aid and he pays all his clothing and any other random needs. There is no parenting plan submitted to court, but we do have a letter from the mommy when she was 6 months old to say she can visit him or he can visit him. There is a good relationship between her parents, but what will my son have to do if something ever happens to spoil that relationship? So this is a typical scenario where I advise people, please enter into a parenting plan, please come to some type of an agreement. So far, whatever understanding these specific people have is in the air. It's somewhere there. Tomorrow she might remarry, he might remarry, or he might meet someone, she might meet someone, and then certain problems will arise. He has parental rights and responsibilities over the minor child because he's partaking in the minor child's life, he's paying, the child is on his medical aid and so on. So if the mother decides she wants to relocate, I'm certain the Department of Home Affairs will ask where the father's consent. Obviously, there's a bit of a problem here because the father's name is not on the birth certificate, and she can say she doesn't know who the father is, as the case may be, and then she will be able to leave the country. So I would advise a specific grandmother to advise the son, please have the granddaughter's or grandchild's name, father's name placed on the birth certificate, and at the same time, try to enter into a parenting plan as soon as possible. And that will just fix things going forward. You do not want to have these type of problems going ahead. I just recall now the question early on regarding the issue of the guardianship over the minor child should something happen to the specific parent. And the question was, can the 18-year-old be the guardian of the child? No, that cannot work. If the father has parental rights and responsibilities over the minor child, and the mother should pass away, the child would obviously have to go to the father. What the mother can specifically do, she can put in a will that she prefers someone to be the guardian, but she doesn't have that sole say because the father is the co-guardian over the minor child. What she can do, and I must probably advise her to do, is maybe speak to the family and tell them, should something happen to me, please approach the court and try to get custody over the minor child. But then at the same time, the question is it better for the minor child to be cared for by the biological father or by a third party? For example, an uncle, an aunt, or a elder sibling. So those are questions the court will have to look at. So if you do pass away and the father is the alternative now, custodian parent of the minor child, speak to your family and tell them, please do something about it. But the outcome of that specific matter will be based upon what is best for the child. Until we get another question, I will go to the second question from our pre-email list. It says the following, it's quite a long one and I'll summarize it. I've been divorced from my ex for the last 10 years. And basically she's saying that it's not the mother is basically bad-mouthing the father, making life very hard for him. She took him to the domestic violence court. There is a parenting plan in place and so on. I made a case against her for being contempt of court, after which she then applied for a restraining order claiming physical, mental and psychological abuse. The case is now currently with the social workers and they're doing a background check, etc. I'm currently doing well for myself and I'm in a good space except for this, and I know she won't stop with this vindictive, intentional sabotaging and lying. Now here's the questions. Okay, here the questions are. It has become apparent that the justice system favors females, especially cases of alleged gender-based violence. How do I even begin to fight a case where false allegations are made and the kids are manipulated against the secondary parent by the primary parent? So here we have a scenario where the father is convinced that once a mother makes certain allegations regarding gender-based violence, she's a domestic violence victim from the specific father, automatically the courts have a certain preference in finding favor of the mother. I don't necessarily believe that at all. I can also believe that certain human beings at courts, they have certain preferences. So the law as such does not work that way, but as anything, you might in a working environment, at a home environment, in a family environment, there will be certain people, certain prejudices. So there could be a specific magistrate, a specific clerk at a specific court, one of 1,000, 10,000 magistrates in South Africa that has a specific view. The moment a mother comes and says she's been domestically violated or a victim of domestic violence or gender-based violence, the court will find more in her favor. But I don't necessarily believe that. A magistrate or a judge will have to make a decision based upon the facts. And when they make a decision, it must be based upon logical principles and legal principles as such. So if the mother can prove that there was domestic violence or gender-based violence, the question will be is, how does that apply to him having contact with a minor child? Obviously, it doesn't really play a role. If a husband and a wife, or male and a female, parents of a minor child, while they were together, they were very much involved in domestic violence. And once they are separated, it continued. That does not mean automatically that the father's rights are limited now. He has less rights to have to his minor children. That is an issue between the mother and the father. The court can put an interdict in place, for example, that the forefather cannot have any contact with the mother, as the case may be, but it should not limit the rights the father has with regard to the minor child. If he is perpetrating domestic violence or abuse towards a minor child, that's a separate thing. That will be very, very irrelevant. But under these circumstances, if there was domestic violence, It's a separate issue. It could play a role on how the court makes an order regarding how contact should be exercised. For example, if the mother does not want the father at all to step close to her house and because there was abuse in the past and so on, then under those circumstances, contact might have to take place at a different place. They can meet in a public place, or a third party will have to collect the child and so on. But I do not agree that all the courts believe that way. And there might be one or two courts that do so, but at the end of the day, prove your case, put forward your case, and the court will have to make a decision. Here's a third question on the pre-questions. You're welcome to pose a question on Zoom, and I'll be there in the next minute's time. Let's go. At what age can a child refuse to go to the other parent? Okay, that's one question. And the follow-up is, on what grounds can the primary caregiver apply for full custody? Where does one apply, and how long does it take? Thanks. Okay, there is no age, and a child cannot necessarily refuse. You don't listen to the child. I always put this scenario to people. Let's say, for argument's sake, you are the mother of the child, you have custody of the child, and tomorrow the child goes to the dad for a weekend. They say there's a birthday party, there's nieces and nephews there, and the child now says, no, I do not want to come back to mom. Must we listen to the child? When do we listen to the child? When the child does not want to go to the dad, but we should not listen to the child when the child does not want to go to the mom. So it doesn't make sense to me. Yes, we listen, we hear what the child has to say, we listen to the reasons for why the child is saying X, Y, and Z, but the child is a child. You consider what the child has to say based upon the age and maturity and so on, but it's the parents that will have to make that decision. For the sole reason, tomorrow the child said, no, it's Monday morning, school tomorrow morning, I don't want to go back to mommy. Must we listen to the child? So if I say 17 years old, so I was saying a 70-year-old child says, no, I no longer want to go to school, and I want to stay by dad, and life is good over there, or I want to change school immediately. So there is no specific age, but at the same time, you have to consider what the child has to say as a factor based upon all the facts. We have to look at the mother, the father, and so on. On what grounds can apply for on what grounds can the primary caregiver apply for full custody? Where does one apply? I mean, the grounds would be what is best for the child. There are millions of grounds, but at the end of the day, you must determine what is best for the child. One ground could be, for example, that you can you can look after the child better than other parent. That's a very good ground. You must prove that. And at the same time, that it will be better for the child to be in your care. But if it's material things, for example, I got a nice swimming pool, I got a nice car, I got a nice room, that doesn't really mean much. You basically have to prove that holistically it will be best for the child. The child will grow up in a better environment, better person, better individual. But if you're somebody that works 24/7, you're always on the go, you have a lot of friends, you work overseas and so on, then obviously you have all the money, but you can't keep it better for the child better than the other parent. It wouldn't make sense under those circumstances. Let's see what's happening on the Zoom. The question is, am I able to state in my will that my son stay in the situation and environment he is now in right now, that is with a third party grandparents, if I were to die? The father cannot afford the child's current upbringing, and we will not be able to uphold him, that is, afford current school fees, etc. Does stating in my will have any power of third party gaining sole custody? The child is 7 years old. So the same question of earlier on, can you stipulate in your will? You can. The only way you can do it is basically if you're the sole guardian over the minor child, and then in your will you can nominate a third party. That's in terms of the Children's Act. But if there's another living guardian, you can stipulate it in your will. It will probably be done as a reference. But the question should be, can this third party look after the child? Does it automatically mean that we should just take another party's rights away? The same way, if the father passes away and he puts in his will, when I die, I would like to give the minor child to my sister, or my uncle, or my aunt. Do we just look at wills? Do we look at this piece of paper and make a decision based upon that? No, we do not do that. So if you're a third party and you do not automatically have parental rights and responsibilities over a minor child, only a mother and a father has parental rights and responsibilities over a minor child. You must understand that. When a child is born, the grandparents, aunts and uncles, it's not their job to look after the child. It's the parents' job to look after the child. And you as a third party can come to the court and say, I am interested. I have a very good relationship with this minor child. The child knows me very well, but I'm being refused contact with this specific minor child. I would like to partake in the child's life. Please, court, allow me specific parental rights over the minor child to visit the child maybe once a week on Christmas Day and so on. That is possible. Then you acquire parental rights and responsibilities, but you do not inherently have it. Only mothers and fathers specifically have it. So regarding that specific question, I can't see much use in the will. It might be a point of reference. The father can come and say, I'm the guardian, I'm the look after the child. He has an obligation to pay maintenance, not the other parent. As I mentioned earlier on, the best to do under these circumstances is to inform your family and tell them, should something happen to you, they should approach a court and they should apply to acquire certain parental rights and responsibilities over the minor child, or maybe for the minor child to reside with them for the sole reason that the father cannot care for the minor child. Okay. If there's no other questions regarding the Zoom, I can now move on to the email questions when people registered for this webinar. Question number 4, my daughter's father isn't adhering to the court order. How do I proceed? I don't have funds to hire an attorney to defend me. How can I proceed without one? Okay, so I think that is one part of the question. If somebody is not adhering to a court order, I would presume either a custody court order, a parenting plan that was made in order of court, or a consent paper based upon a divorce and so on, alternatively a maintenance order. That person is in contempt of court, and our advice to you is to approach the court, and the court will be able to process the matter. So if somebody is in contempt of court, it's a criminal offense, and the person can be jailed and so on. So approach the court and lay a complaint. I don't have funds to hire an attorney to defend me. You do not need to have an attorney to defend you. You can defend yourself. Obviously, it's always advisable to have legal representation. The same thing with accounting, get an accountant to do things for you, a medical doctor to do medical things for you, and so on. But it's not a requirement, but please look around, maybe like the Legal Aid Board, the Legal Resources Center, certain places that do work for the bono and so on. And it goes further. At what age should children start sleepovers at another parent's residence? I need to know more about parenting plans. Okay, sleepovers can take place from day one. The child can be 1 day old, for argument's sake. Maybe not 1 day, but quite young. It all depends upon the facts of the specific matter. I like posing this specific question, and I ask this question to many moms. They come to my office and I ask, if you were still living with a father and things were perfectly fine, and you had to go to Johannesburg or overseas on work, would you allow the father to care for the minor child while you're away? She said, of course, yes, perfectly fine. That he's a father. He must look after the child. So while I'm away for a week or two, my child is 2 months old, he should care for the child. But what happens is, once the parties separate and they divorce and so on, then it becomes a problem. They do not want the child to have any sleepover contact and so on. So even with the scenario, the mother fell pregnant, the father and her are wonderful friends and amazing friends, etc. Now she has to go overseas for 2 weeks. She'll drop the child by the father's house, although the child is 2 weeks old or 3 months old, as the case may be. So there is no age. It all depends on the facts of the specific matter. Okay, going further over here. My 4 children live with their father and his 3 unmarried siblings. While the father and I are in arrangement with regard to the children not having their own devices, cell phones, Xboxes, and so on, basically the other family members living in the specific house allow the kids to use these specific things, and they're overstepping their boundaries. Can the courts help via an official parenting plan? The extended family performs parenting duties to a significant extent. Typical scenario where third parties like grandparents, aunts and uncles are living in the same house with the minor children, and then you have the one parent living in the specific house like the father over here. It's a parent job to parent minor children. If third parties come on board and they're involved, you need to speak to those specific third parties. But you can't really get third parties involved in a court litigation matter and telling them how they should parent the kids, because it's the father or the mother are the people that are primarily responsible for caring for these kids and parenting these specific children. And if third parties are involved to assist, they're acting basically as agents for these specific parents. So under this scenario, I would advise you need to sit down with the father or the person living with these specific in-laws, and you need to tell the father to please put his foot down and not allow these specific third parties to intervene in the upbringing of the minor children. Okay. One further comment. Thanks for the reply. Do you know how we can go ahead to add my son to the birth certificate even though the daughter is 7 years old already? Yes, you go to the Department of Home Affairs and you make an application to them. They don't listen to the father. I'm currently going through a divorce. My husband sees to everything financially. I'm working, but I earn less than a third of his salary. Once we are divorced, who pays school fees? I have 2 adult kids, 2 minor kids. Who pays for varsity? My husband and I are not in place to discuss a way forward. You guys must come to an agreement regarding who pays for what. That is the simple of the long and the short of it. If you cannot come to an agreement as to who pays for what, you need to now decide, okay, I think it's fair that because I earn a third of his salary, you should pay for this, I should pay for this. But the starting point would basically be is who's the primary caregiver of the minor child. So if you will be the primary caregiver of the minor child, simple, perfectly fine, you will have certain type of expenditure. You will have accommodation expenditure, petrol, water, electricity, and so on, clothing. So you need to unpack that. Then you have to look at your salary, and you have to look at the father's salary, and in this case it's 1/3, 2/3, and then you have to now say, Dad, you need to pay so much money towards the minor kids because this is what they cost. Regarding school fees and so on, the same principle applies. At the end of the day, holistically speaking, the father should pay 2/3 and the mother should pay 1/3. That is how, that's a quick and long and short example of it. Sometimes we come to an agreement where the mother says she pays for all the child's day-to-day activities, but the father pays for all the medical and school fees and so on. So you have to work it through with the other parent, but if you cannot come to that specific agreement, then the court will get involved and the court will decide what is best for the minor children, what's fair and reasonable under the circumstances. Okay, we're running out of time. We've got 2 more questions. What do you do if the father does not want to sign a parenting plan? Same like earlier on, if he doesn't want to sign the parenting plan, you finalize the matter in court. The same way if somebody owes you money and he doesn't want to pay, you take him to court and the court will finalize the matter. It's a long question, but the last one. Can he try to take the minor child of 5 years old from me in Cape Town? We are reliant on the father for all expenditure. Parenting plan never stated that I have to tell my ex-husband if I relocate provinces and so on. I'm the primary caregiver. The minor child is already in a new school in a new province. School starts on the 18th and so on. Okay, so this is the scenario. I did it early on. I'll just summarize it. Whereby the mother is a primary caregiver. She moves to a different province without telling the father, but the father pays for all the minor children's expenditure. And it seems to me now the father is not doing that anymore. If the court order is in place and the court order orders the father to do certain things and he does not do so, he's in contempt of court, and then under those specific circumstances you can approach the court and lay a complaint against him for that. That's the long and the short of it. I do not want to comment as to whether or not you are allowed to go to a different province or not. That will obviously be based upon the specific provisions of the parenting plan and the court order. We have another comment. Oh, thank you for your information and your time. You are welcome. That is now basically the long and the short of it. I think we've just made it to a half an hour, just over half an hour or 35 minutes. Please, at the end of the day, no parent can say, I want this, I want that. There needs to be a logical basis behind it. And that's how you win these specific matters in court. That's how you become successful with these type of matters in court, because you proceed with these matters on a logical basis and the court applies logic to these things. If your case is logically sound and it makes sense under the circumstances, then obviously the court will grant it in your favor. But if your case is based upon ego and saying, no, I am the mother and I want this to happen, I want that to happen, you won't get very far with your case, as I mentioned earlier on. And the same with fathers, for example. If your attitude is, no, I'm paying all the money, I'm paying for this, I'm paying for that, therefore I should have a right to have a final say regarding my minor child, you're wasting energy, you're wasting time, honestly. You're going to spend a lot of time, a lot of energy, a lot of days, a lot of months with that specific attitude. And at the end of the day, when your attitude changes and it starts becoming logical and reasonable and sensible in your approach to the specific matter, it might just be a bit too late. So from the word go, speak to an attorney, speak to a lawyer, determine what should my strategy be to be successful in my case. And many times you'll notice when you're sitting with a lawyer, with a seasoned family lawyer, is that for the first half an hour he will disagree with everything you're saying. And then we will start getting on the same page. And then you'll see how your matter starts unpacking and unturning. You get a different vision and how to deal with these specific matters, and you will start seeing success. Because many times it's possible that you have no rights. It's possible. The mother, you have no rights, or the father, he has less rights, or as the case may be. That is a factual thing. But you need to know where your stance is. You need to know where you are at the start of your case. And then from there on, you can move forward to getting the proper success, etc. So, for example, if a father says, I don't want to see my child, I never saw my child for the last 6 months, I'll only see my child if the mother allows me to see the child on my terms and conditions. That's silly. That will get you nowhere. Phasing contact. Do whatever you can do in order for you to see the minor child, eat humble pie and so on. So when you do get to the court in 3-4 months' time, you've laid a foundation. And then you can tell the court, I have seen my child for the last 6 months, for the last 2 months, or last 3 months, and then the court will specifically, under those circumstances, give you specific rights which you did not have before. Thank you very much for your time. I appreciate it. We'll have a webinar next week again, and watch this space, and you should be able to get your notification of these webinars. Have a lovely day. Thank you.